Yes, prosecutors make mistakes, especially during DUI trials. Hi, I'm Matt Landsman, board certified criminal trial attorney with more than 20 years of experience. And I wanted to take this opportunity to talk about some common questions I get about DUIs. That's one of the most common areas of law that I get asked about. And a case came out named Sheely v. State that kind of answers some questions. So I wanted to talk about it for everybody. I thought everybody could be helped by this. So in this case, the Fourth District Court of Appeal judges determined that the error was that during the closing argument of the case, the prosecutor commented on the defendant's decision to remain silent and not, and also to not that he didn't participate in the field sobriety exercises or breath test, which are voluntary. So here's what was said. I'm going to read it. I'm going to read it line by line. The quote from the case: um, "A defendant." So in quotes, the defendant says no when taken to a room safely designated for him to perform field sobriety exercises to dispel the suspicions. He had an opportunity to dispel the suspicions, and he also declined to dispel the officer's suspicions by submitting to a breathalyzer test. That's language that the prosecutor used in Sheely v. State on August of 2024. So let me be clear, that is not just inappropriate, it is unconstitutional. They can't say that. They can't argue that. It's improper. Now, what the law actually says is that every defendant in the U.S. has the right to remain silent. And the prosecution is not supposed to be commenting on that. The right is enshrined in the Fifth Amendment, and trial law is pretty clear on this. The prosecution cannot comment on a defendant's silence or suggest that exercising that right is evidence of guilt. That is prohibited. More importantly, the burden of proof in a criminal trial lies entirely with the state. It's another kind of principle that goes together. So the defense has no obligation to prove innocence, obligation to offer explanations, or dispel suspicions. It's like a common thing you would hear from police when during an arrest, something like that. But that just because the police say that on the road doesn't mean it is proper for a lawyer to be saying that in criminal court, specifically, certainly not the prosecutor during a closing argument. Now, the moment a prosecutor suggests otherwise, like in this case, it's called burden shifting, and in this case, they shifted the burden and improperly, and that undermines the fairness of the trial. So, as the court emphasized in this Sheely case, these comments were prejudicial. They violated the defendant's constitutional rights. The conviction was reversed and remanded for a new trial. Now, the reason this matters, what does it mean for everyone else? It means that the justice system is not perfect. It means that even today, constitutional violations happen in courtrooms across the country. They certainly happen in Florida. And it means that you, if you're ever accused, need a defense that's vigilant because you have to do these things on the fly, like while real time, while this is happening, you have to catch these things and try to stop them up at the time. And even if you're not accused yourself, you need to you want to see the value in other people having a defense and due process since it affects your rights. So even if it's just because if you think, well, I would never do anything wrong, so I don't need to be concerned, you want to have other people being defended too, because they're really defending everyone's rights when you have fair trials and fair procedures. So think about this. The defendant in Sheely had to go through a flawed trial, endure a conviction and appeal, all to get back to square one. That's a long and painful road. There's a lot of time, expense, and emotion that this defendant would have to go through. And that shows us why due process matters. That's what it ultimately shows at the end. Police and prosecutors are not evil. They are human and they make mistakes. They cut corners sometimes, and sometimes a core legal principle can get bent. Why it gets bent? I mean, it makes getting a conviction easier. It makes the job easier to not learn about the law or to execute it properly. But that's where the defense comes in. If having defense attorneys who are vigilant and knowledgeable about trial practice and protecting your rights is the goal of which is to try to stop things like this from happening. And you see cases get published around Florida, around the country, that kind of document these kind of mistakes that happen. So that's where the defense comes in. If you want to read more about the Sheely case, I've linked the opinion into my blog. Um, and if you found this video helpful, be sure to subscribe and share. Until next time, Matt Landsman for you.